Okay, let's go on the record on cause number DC 178336, Jennery Francois versus Parmenter Realty and Investment Company. Counsel, make your appearances.
Mohammed Saeed for the plaintiff, Your Honor.
Kevin Poteet for the intervener.
Allison Lockhart for defendant Parmenter Realty.
Okay, I've read the briefing on this. I did have a number of questions, but we'll go ahead and let you guys get started.
Judge, would you like me to begin since it's our motion?
Sure.
Okay. Judge, you may recall back in March, we had a previous hearing on an MSJ filed by the plaintiff on these exact issues. And as a result, you denied the relief sought by the plaintiff. However, we could not reach an agreement on how to apportion the money. It is not, I want to emphasize at the beginning, it is not the intervener's position that the plaintiff's attorney is not entitled to 1/3 of the total recovery. That is absolutely appropriate. We believe that the plaintiff's attorney is entitled to $50,000 for attorney's fees plus reimbursement for every dollar of expenses incurred by the plaintiff's attorney in procuring the settlement. So I want to start with that. The question that the plaintiff continues to raise is they believe that they are entitled to basically double dip on attorney's fees. That is against the statutory scheme. We have 417-001, 417-002, and 417-003, which control. We also have two Supreme Court cases that are directly on point. The first is Argonaut, and the second is Ledbetter, which is a Supreme Court case from 2008. And it states the law governing this settlement is simple. The compensation carrier gets the first money a worker receives from a tortfeasor. Our lien in this particular case is over $300,000. We were not involved, the intervener was not involved in the prosecution of the case. However, it did go to a mediation. And at the time of the mediation, the plaintiff was well aware of what the lien was, did not seek a reduction of that lien at that time, agreed to settle the case for an amount about half of what the workers' compensation carrier's lien was. The law is clear. 417-003 indicates that the claimant gets, or the attorney gets 1/3 plus cost. The remainder goes to us. There's also an ethics opinion that affirms this. In fact, in the SIR reply from the plaintiff, they cite to a case, Alcorta, which is exactly on point. In that particular case, the district court awarded the plaintiff's attorney a 40% contingency fee. The lien in that case outstripped the amount of the settlement. In that case, it was a policy limits case. And in that case, the Court of Appeals reversed and said that that is against the statute. By statute, the only amount of money that the plaintiff is entitled to is the amount of $50,000 plus all expenses. The claimant or the plaintiff continues to argue that we're not willing to pay him fees. We are. We're perfectly willing to abide by the statute.
I have to admit, I did read the SIR reply. I never saw that. Did you file a reply? I never saw an actual reply, but I did see the SIR reply. Did you file a reply?
We did not file a reply to that, but I will point out to you,
No,
Your Honor.
did you file? So there was a motion, a response. Was there also a reply and then a SIR reply?
Yes, there was a reply. Yes, Your Honor.
Okay, I never saw that. So maybe, when did you file that?
We filed it the day after their response, and I can get that over to you. But I'd like to point out in their SIR reply, it's interesting. In their original response, they want you to apply the NAP decision, the NAP order. And then when we get to their SIR reply, they're like, oh, never mind. The NAP decision does not apply. They're trying to have it both ways. The law cannot be any simpler. Ledbetter is a Supreme Court case. We also have Argonaut, which is also a Texas Supreme Court case. Both of them support our position that the plaintiff's attorney gets $50,000 in this case and expenses.
So I'm going to share a screen on the reply real quick, because I have to admit, I don't like the law in this area, but I want to make sure that I'm kind of following both arguments. So you have the proposed settlement is $150 net amount intervener could be entitled to. Where does the 60% times 150 come from?
Your Honor, what they're attempting to do is take 40% off the top. They want to get paid their contingency fee off the top. And we did not enter into an agreement with them to pay 40%. It's against the statutory lien. The first money comes to the workers' comp carrier. We are entitled to that entire $150,000 subject to 417.003. So you'll see they take 40% off the top, and then they take another third off the 90%. So,
Your Honor, that's 417.002, if I may, says they're entitled to recover the net amount to the claimant. And that means what is supposed to go to Mrs. Francois after our contingency fee is taken out. So this is the problem that we keep running into with intervener. They didn't participate in this lawsuit at all. They were invited to participate, they declined. They were invited to the mediation, they declined. I myself reached out to them the day of mediation. No phone call was returned, more than once. And they are coming in here trying to get a free ride.
no.
The Texas Labor Code is straightforward, says they are entitled to the net amount recoverable after net amount to claimant. So that means I take out my attorney's fees first from this 150. Then at that point, we look at, did they participate? Did they do anything? Did they even lift one finger? And they did not. Then I'm entitled to attorney's fees out of what they're recovering. Now, I went ahead and made sure to state in my reply, that my intention is not to double dip. And that's why this ethics opinion is irrelevant here. We all know what happens in these types of cases. We always enter into a three-way split. I have done this dozens of times. Why this intervener, this lien holder, is refusing to enter into a three-way split is beyond me. We offered that, and I still continue to offer that even after they intervened and spent countless hours making me work and my client wait. I still offered it. The reason the three-way split works is so we can avoid to have these types of cases and this type of deck action that we brought before you. The law is clear on this. If they don't participate, I am entitled to attorney's fees, 1/3 of attorney's fees from what the workers' comp carrier is getting. And if you do the numbers based on that, taking out my 40% and then taking out 33% from what the workers' comp carrier is going to get, we come out to almost a three-way split. And I've already stated to intervener that my intention is not to keep all of this attorney's fees. That's not what I'm doing. I promised my client a certain amount. And my client said, yes, that sounds good. Let's go ahead and settle the case, because intervener was nowhere to be found. That additional money that I'm getting from intervener for doing all the work and getting them money back for their claim.
Mr. Syed, let me do this. Let me try to, I get your argument, and I don't.
Thank you.
My main goal here is I don't want to be reversed. And I'm concerned if I follow your path, it'll be reversed. But I want to figure out the NAP calculation, and I'm not sure I fully follow it. So, Mr. Petit, so the NAP total settlement was $23,250. Is that right?
That's right.
And the lien was $19,000.
Right.
506. And so the net amount to the plaintiff would have been 3,743.
Correct.
And then I don't quite understand all of this.
So you get the attorney's fees.
So was this a situation where the carrier did participate?
No, no.
Okay.
And Your Honor, if you look at the Alcorta, which they've cited in their server.
Let's deal with NAP right now. Just what did they do in NAP?
Okay, what they did in NAP is they gave first money to the workers' comp carrier, which is what they're required to do by statute. And then after they took the first money, there was $3,743.73 left. So what happens is, of the $506.27, the plaintiff's attorney gets a third of that under the statute, and then can take the remaining contingency fee out of what is the net amount remaining after satisfying the lien.
Let me see.
And in this case, I think they took a 0.36.
Okay, I still don't get, I guess I don't get, I guess I still don't understand the math in NAP. So you have 23,000 as a gross settlement. The lien was 19,506. The net amount is 13. I guess I would have thought with NAP that you take 23,250 and then take 19,506, take a third off of that, and then that would be 23. But are they saying that the attorney only gets 1,000? That's NAP's recovery. What is the amount that the?
Okay, so the problem with looking at it this way, Judge, is it does not account for the attorney's fees paid out of the 19,506.27. That is just assumed because it's consistent with the statute. So what you're seeing there for the attorney's fees is what the attorney's fees are paid to the plaintiff's attorney out of the plaintiff's recovery. So in other words, out of this 19,506.27, in addition to the attorney's fees that are listed there, he would also get a third of the attorney's fees from the 19,506.27.
So what I guess what did the insurance company get out of the NAP in the NAP case?
2/3 of 19,506.27.
Minus expenses, if there were, and minus
Correct.
cost, I guess.
Correct. Absolutely.
That isn't how this calculation works, though. It doesn't seem like.
Well, that's because it's not accounting for any attorney's fees paid by the insurance carrier.
Okay.
And so, Your Honor, I understand what Mr. Saeed is saying about section 4017002, but all you have to do is read the Argonaut opinion, which states, rather than the employee owning the money and being forced to disgorge it, it is the carrier is first entitled to money up to the total amount of benefits paid. That is, except for attorney's fees and expenses pursuant to section 417.003. The carrier is otherwise entitled to the entire amount to reimburse benefits paid to the claimant. This was reaffirmed by Ledbetter. In that case, the court held that a settlement cannot be structured in such a way so that the plaintiffs and their attorney got all of the funds and the carrier got nothing. Told otherwise would not allow the carrier first money. The critical point here is first money. It's not Mr. Saeed, it is not Ms. Francois, it's not their money. It is the carrier's money, subject to 417.003.
Your Honor, every other lien holder, such as MedPay for auto claim, Medicare, we're talking about assignment of benefits, everything else waits to get paid until attorney's fees are taken out based on a contingency contract. You take out attorney's fees based on a contingency contract, and then you deal with the lien. Here, you got a workers' comp carrier coming in saying, no, no matter how much work you do, and despite that contingency contract that's been entered into, even though we sat on the sidelines for years, didn't lift a finger, we get to take our money first. That's not the way it works in Texas, and that's not the way it works in Dallas County. And that's why most of the time, if not all of the time, you enter into a three-way split, or at the very least you negotiate. In this situation, the intervener did not negotiate, did not even entertain anything like a three-way split. They just flat out said, we reject your offer for a three-way split. We don't even want to counter that offer. We're going to intervene after you settled the case and litigate it for 2 years. And now we're going to take the lion's share of this. That's not fair. That's not equitable. And I disagree with counsel's points that he has case law on point. He doesn't. The fact of the matter is the statute, Texas Labor Code, says straightforward, they are entitled to recover after the net amount to the claimant. Well, what is the net amount to the claimant? The net amount to the claimant is after the contingency fee is taken out. Because if it wasn't for Mrs. Francois coming and retaining me and signing a contingency agreement for me to file this lawsuit and we litigate together for 2 years, they would not have any access to this money or anything like that. They wouldn't have filed the lawsuit themselves. They wouldn't have litigated this themselves. So this, I believe, is very important, not only for my client and my firm, but for every other plaintiff out there and other firm out there that does these cases and take them. Because what are we going to do if now we have interveners like this lien holder coming in and taking the lion's share? You're not going to have these lawsuits. You're not going to have these claims. It doesn't work that way. It is not fair. They can't come in there and say, we take it all and leave you with just a minor.
So, Mr. Petit, where do you cite to Ledbetter or Argonaut? I didn't see that in your reply or in your motion.
Okay. In our motion, you will see it on page 7 of 11.
Okay, let me see.
It's that basically that whole page.
Okay. And then where is Argonaut?
Hold on just a second, I'm looking. Not sure that we cited to Argonaut in our original report. Let me look at mine.
Casey.
The Ledbetter is the one that's more recent. It's 2008. And it's directly on point. And it cites to Ledbetter within that case.
I'm sorry, say that again.
The Ledbetter cites Argonaut. I don't know that we necessarily individually noted it. The Argonaut case is 2002. The Ledbetter case is 2008.
Okay.
And in that Ledbetter decision, it notes that any net recovery to the amount past benefits goes to the carrier, but it starts off that paragraph by saying, if there is a recovery, rather than the employee owning the money and being forced to disgorge it, the carrier is first entitled to the money up to the total amount of benefits paid.
Mr. Said, how do you distinguish Ledbetter?
Your Honor, Ledbetter talks about money to the intervener. It doesn't specifically state that they get to take their money before the contingency contract. That's NAP, and we disagree with NAP. So that's why I'm saying, he's saying Ledbetter's on point. Ledbetter just talks about first monies, which is the same thing what the labor code says. But what I'm saying is the labor code, when it says first money going to the intervener, it's talking about after contingency fees are paid.
That's not
After
right.
contingency fees are paid.
No,
What is the calculation in Ledbetter?
I don't know that they did a calculation. I think they reversed it and remanded it down to the court.
Okay. And when's y'all's trial setting on this?
I don't think we have a trial setting because we thought we disposed of it.
September 7th, 2021, Your Honor.
Okay.
There is no question of fact here, though.
That's
Not one.
It is question of law. We have filed a stipulation, and we've added that to our response to the summary judgment. It's Exhibit A. I believe, Your Honor, I believe the way the other Dallas courts have done it and the way we do it here in Dallas is the proper way. And I hope intervener goes back and talks to their client and comes up with a good settlement or at least counter. Because what they're trying to do here is not right. You can't sit on the sidelines for 2 years, not lift a finger and come in and take the lion's share. That is not right, and leave my client high and dry.
And let me just say, I do generally agree with Mr. Said that there is a negotiation process that goes on. And we have had several attempts to get the intervener to reach an agreement. In fact, Your Honor, you may remember we had a hearing on this back over a year ago where the adjuster was present to prove up the amount of the lien. And you asked him, you went off the record and you asked him if he would agree to the 50-50 split. And he said no. And that was, I do agree that that is generally how it's done, but you cannot get past the statutory scheme. This is not MedPay. This is not a doctor working on an LOP. This is a statutory scheme which has been analyzed at the Supreme Court. And at the Supreme Court, it is clear the carrier gets first money, not subject. You cannot, if you look at 417.003, the statute says the attorney does not get more than 1/3, up to 1/3. We are willing to give him his 1/3, but that first money is ours. He can't take a fee and then take another fee.
Are there any cases that interpret Ledbetter in the way that you've said, Mr. Petit?
Yes, in fact, they cited it in their Argonaut, in their SIR reply. And it's the Alcorta case, which I believe you can find on page 9 of their SIR.
Okay. All right, guys, I'm gonna make a ruling on this within the next 3 weeks. Have you already submitted orders, each of you?
I will send one that's on point, Your Honor.
Each of you send me a proposed order, and I'd encourage you guys to try to work it out. Mr. Said, I will say this, I've dealt with this issue before. I hate the statutory scheme. I think that I've had Hartford actually in this court before, I think, on this issue. I just think in the future, if you're ever dealing with Hartford, before you cut a deal, you got to get them to agree to it, or you may run into this, and in other workers' comp carriers. But I haven't looked at the law in over a year on this, and I know we have a new Court of Appeals, and so I want to make sure that we have, we're up to date on the law and everything. And I think it's kind of deplorable what Hartford is doing here, but it doesn't do any good to not follow the law. I've done that in the past where I thought something was wrong, and then I did what I thought was right, and then the Court of Appeals just reversed me. I don't know that that's super helpful. So, but we'll see if there's any way that we can come up with something that's equitable if that's allowed under the statutory scheme. So, anyway.
Thank you, Your Honor. And I believe, if you do dig deeper on this, I believe there will be a way that you can find this. I'm just looking at the statute itself and thinking the way it's written and what we're planning on doing with the money that we get from Hartford. If we get that, we plan on giving that to the client because that's the fair thing to do here. And I will reach out to Intervenors Council as soon as we hang up to see if there's anything else we can do to work this out. I've always been willing to negotiate further. And we did try to reach out to Intervenor more than once. They must have been busy during that time. And they only became excited about this thing when they knew that there was a settlement. Beforehand, they didn't want to participate. They didn't want to negotiate. We tried, but it is.
No, I'm not blaming you. That they're taking advantage kind of your hard work and goodwill, and I think it's horrible, and I think it's a long-term bad strategy. Because if I was a plaintiff's lawyer in your situation, I saw another case with a Hartford lien, I would just not litigate it. I mean,
absolutely correct, Your Honor.
I mean, because you have no incentive to do it if they're not going to negotiate, and there's not enough. I mean, that's why people do a 1/3, 1/3, 1/3 is that you have, in the long run, you want to be able to, the next one, you want the plaintiff attorney to get as much money as possible. It's in Hartford's best interest. But in the future, you probably won't take a case like this. I wouldn't if I was your plaintiff's lawyer.
You are correct.
But we're going to take a look at it and see if there's anything we can do, and we'll let you know something as soon as possible. Okay.
Thank you, Judge.
Thank you,
Thank
guys.
you, Judge.
All right. Our next one is Flaherty versus Steele. Anyone here on that case?
Yes, Your Honor. Glenn Fall, representing Western Dairy Transport, and Jimmy Steele were the movant.
James Fegan, representing the plaintiffs.
Your Honor, this is Gene Ree on behalf of Double C Services, Inc., the defendant.
Okay. Tony, let's go on the record on cause number DC 1916864, Flaherty versus Steele. Counsel, make your appearances.
Glenn Fall, Western Dairy Transport, and Jimmy Steele.
Your Honor, Gene Ree on behalf of defendant Double C Services, Inc.
James Fegan here for the plaintiffs, Charlotte Flaherty and Christine Reese.
All right, let's proceed.
Yes, Your Honor. By way of brief background, this is an accident that occurred on 35, wherein a pickup truck hydroplaned and from the left lane of 3 hit a concrete barrier, center barrier, spun out across 3 lanes of traffic to the other side. Traffic slowed down, did not stop. The plaintiffs were in the middle lane. Mr. Ree's client, a fellow by the name of Waits, a driver for Double C, was in the center lane as well. So plaintiff center lane, Waits center lane, and my driver for Western Dairy, Mr. Steele, was also in the center lane back over. The plaintiffs had slowed down, and Mr. Waits' testimony was that he liked to have distance between himself and vehicles ahead. So he just, as a caution, moved over to the right lane, a moving highway lane, and stopped. Because during the process of moving over, he noticed the pickup truck spinning out. So he says he came to a stop. And that's significant because he's trying to distance himself from any involvement in this accident whatsoever. He then claims that my client, who's in the center lane, somehow hits the left rear of his trailer, rides all the way up the side of his truck, which he says he can see in his left view mirror. He sees all this happening, and that My client then hits the plaintiffs. That's what Mr. Waits said happened. What we now know is Mr. Waits was on his cell phone, and after this accident, Mr. Waits gratuitously testified for the first time that my client got out of his truck and said he was looking down, which created a false cell phone narrative. And it's false because my client is extremely unsophisticated when it comes to electronics. He has a flip phone. He doesn't text. He doesn't do internet. And he was not on any call. The phone was not used for hours before and hours after. Significant because, as it turns out, the person, Mr. Waits, has accused my client of being on the phone or looking down, which implied he was on the phone. Mr. Waits was on the phone right up to the minute of this accident. And because we know he never stopped in the right lane, per plaintiff's expert, per defense expert, and we know that what happened based upon a video, a dash cam that the plaintiffs had in their vehicle shows Mr. Waits trying to, and this is significant because he's on the phone, he's not paying attention, and he has one of those oh bleep moments where he cannot stop safely in his lane completely and not hit the plaintiffs. He's not going to be able to do that. So he does this evasive maneuver, which we can see in the video, where he's actually threading the needle. He's partly in the center lane, partly in the right lane, and having to try to come around the plaintiffs and not hit a car that is in the far right lane. We know he wasn't stopped. We know he's coming around. We know he's trying to thread this needle, and we know it's an emergency maneuver. What does that have to do with anything? What that has to do with is what my client was able to perceive. What my client was able to perceive is a truck that was starting to slow down and then starting to move over.
Is this I thought this was a motion to compel. Is this a summary judgment?
No, it is a motion to compel. The reason
Okay, well, so why are you going into all this stuff?
The reason is I asked for the corporate representatives of Double C, the trucking company that Mr. Waits worked for. And what we got, and I got a response to my motion yesterday, so I didn't have a chance to file some kind of reply, but in response, when I asked for the safety person at Double C and the corporate rep at Double C on December 9 of 2020, Mr. Reed asked me, who do you specifically intend to depose? Or can you send topics? So I said, safety director and persons with knowledge of policies and procedures, as well as that particular driver. January 20 of 2021, I got an email. Mr. Reed emailed my associate who said, hey, what about the depots of the corporate rep? He said, Mike, there is no basis for Western Dairy to depose the representatives of Double C. Western Dairy's affirmative defense is based on the alleged negligence of Mr. Waits at the time of the accident, which is not even supported by Mr. Steele's testimony, which is why I went into all the facts that I did, and does not implicate any acts of Mr. Waits' employer. Consequently, we will not be producing any Double C representatives for deposition. So we sent out deposition notices. They were quashed. And despite the fact that plaintiff has alleged the same things against Western Dairy Transport and Double C, they've alleged negligent supervision, negligent hiring, negligent training.
Let me hear from Mr. Reed.
Your Honor, thank you. So we've heard quite a regurgitation of substantive facts, some of which are accurate, some of which are not. But the thing that strikes me and hopefully strikes Your Honor is where's the connexity? He's co-defendant's counsel has pleaded in support of his motion to compel the production of these corporate witnesses issues regarding whether or not my client was stopped or not stopped, whether or not he was on the phone or not on the phone. Incidentally, he's made some very serious fact references, but let me just point out that with regard to the phone record, it's entirely inaccurate. Co-defendants counsel fails to account for the fact that the data is shown in UTC time, which is Greenwich time, which is 6 hours different from our time. And then he also fails to recognize that the page that he's citing from the phone records references data usage, not voice telephone usage. So that's out the window. But regardless, how is my client's corporate representative going to testify and have anything to say that it was more or less likely that my client was stopped at the time, more or less likely that he was on the phone at the time? Furthermore, the topics that we did receive for the deposition notice of the safety director, it's the usual boilerplate policies, practices, and procedures topics. None of it has to do with cell phone usage or whether or not my client was stopped or not stopped. There really just isn't any compelling.
Let me just say this. I'm going to allow the deposition to take place. Have you guys kind of conferred on the topics?
No, Your Honor, and I'm more than happy to work with Mr. Ree on what I believe would be a narrowing, because while he thinks nothing they had is anything to do with Mr. Waits, simple things. Their cell phone policy, because I can tell you the UTC issue's a red herring. I'd want to know about safety training, driving, assured clear distance, distraction, what safety meetings you've done to try to allow this not to happen. So I can work with that. I don't need to do a scorched earth. And I've been to his client's business. It's a shack. I bet you they do not have 2/3 of what I'm asking for. And it will be a very quick deposition when they say, we don't have that, we don't have that. But I can know. And if we have a problem, I'm more than happy to schedule a time to come back.
So what I would suggest we do is I'm going to put you guys into a breakout room right now while I take care of the next hearing, and you guys try to work it out in terms of the preferably, hopefully, a date for the deposition as well as the topics. If there's a particular issue that we need to go into greater detail about when it comes to the topics, then I'll discuss that with you when you come back. So I'm going to send you with one of my interns. The intern will make sure to teach you how to come back to this room after you're done. And then but we'll give you about 20 minutes to try to work everything out. All right, guys.
Your Honor, real quick, I'm just for the court's reference, this is also the case. You had a hearing with Mr. Kramer at my firm about the State Farm records that have a statement in them written down by the adjuster of the fellow who's a responsible third party, the one that spun out. And I understood you were going to be making a ruling soon on that one, but it relates.
Was this the big box that you guys sent me?
It would have been State Farm would have sent it, yes. I don't know how big it is because I've never seen the records, but we just asked for their file as it relates to what this guy said to the adjuster when she wrote it down. Because when she read it to us, it said, he told me he spun out and caused the accidents behind him, which we thought was kind of.
Give me a second. I'm gonna.
Sure.
Is the attorney for State Farm here?
No, I believe they were present at that hearing arguing against the production. And that's when you asked for the documents in camera. And I believe everybody's just waiting.
Was
for
that
you.
it?
Yes, that's what she said.
Okay, let me see. This is, I don't know if you can see it, this is the box.
This is for the next hearing.
Great, thank you.
Did not mean to disrupt the docket, Your Honor. I just.
Yeah, this is probably at least 500 pages of documents. I don't know why I got all of this. What am I supposed to be looking for?
One very simple thing. When adjusters, I'm sure the court is aware, when they do anything on a file, they have a diary where they used to write it in, now type it in and date it. Today I called so-and-so, today I asked for the police report. There should be an entry where she spoke with the Mr. Willis, their insured, who was driving the pickup truck, and where she typed in what he told her happened. And when she read it to us before we had to compel, she said that he told, and she was reading, told me that he spun out and caused the accidents behind me. That one page is all I'm looking for. They're denying now that she said it. Not them as in Mr. Reed, but State Farm.
Okay. Well,
It sounds like a good job for an intern.
I mean, let's see, actually, I'm wrong. There are 17, over 1,800 pages of documents. I'm not very good at estimating this, I guess.
Not sure why, because they settled very quickly after this incident. They paid the policy limit.
Let me make sure this is the right thing. Christopher Willis is the insured.
Yes, it is. He is.
Well, we'll have to figure out how to do this. I'm going to put you guys into a breakout room, and then I'll see if I can take a look at it. One of my interns take a look at this. So hopefully it's near the beginning. But go ahead and go to the breakout room. I'll go ahead and set that up right now. Okay, Guillermo, can you come here? quite a bit there. They didn't really need to send me everything, but. All right, are you guys all here for the minor prove up?
Yes, Your Honor.
Okay, so who's here with the plaintiff's attorney?
Your Honor, I represent the two minors in the Antonia Vane case.
Okay, and who the guardian ad litem is Ms. Meeks, and the defense attorney is Mr. Jenkins here.
Yes, I am,
And
Your
then
Honor.
we also have a Mr. Liberato. What are you here for, sir?
I'm interpreter.
Okay. And where is oh, there we go. And Ms. Portillo is right there. Okay. Okay, I think we have everybody. All right. Let's go on the record on cause number DC 192357, Bang v. Mohammed. Counsel, make your appearances.
Sachi Dave for plaintiffs.
Young Jenkins for defendant.
Tamara Meeks, the guardian ad litem for the two minors.
All right, Ms. Davi, go ahead and call your first witness.
Okay, at this time I call Jackie Portillo.
Ms. Portillo, please raise your right hand. I'm sorry, I need to swear in the interpreter first. Are you calling her with an interpreter?
I am not calling her with an interpreter. I am only calling Miss Vane with an interpreter.
Okay, so I just can swear in Ms. Portillo then without an interpreter. All right, Ms. Portillo, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yeah, I swear.
All right, let's proceed.
Miss Portillo, please state your name for the record.
Jacqueline Portillo.
Okay. And Miss Portillo, were you involved in an accident? I apologize, Your Honor. Give me just a second.
Can't hear you, Ms. Davi.
I apologize. Ms. Portillo, were you involved in an accident on April 22nd, 2018?
Yes, ma'am.
Okay. And did you seek treatment for injuries sustained in that accident?
Yes, ma'am. I went to therapy for therapy.
Okay.
I don't know the name of it, but yeah.
Okay. And did you seek treatment at a hospital?
Mm-hmm.
Okay.
Yep.
Can I ask a question here? Is Ms. Portillo one of the parents or next friends, or is she the actual plaintiff?
She's one of the minors, Your Honor.
She's one of the minors.
Yes.
Typically, you're going to have the parents testify, and then she'll verify. Is she 18 now?
She's not, Your Honor.
Okay, let's deal with the parents first.
Okay. I apologize, Your Honor. Okay, at this time, I would like to call Miss Antonia Vane, and I will be calling her with an interpreter, Your Honor.
All right. Mr. Greta, please raise your right hand. Do you swear or affirm the testimony about to you swear or affirm that you'll faithfully translate the matters in this case from Spanish to English, from English to Spanish, to the best of your ability, so help you God?
I do.
All right, let's proceed.
All right.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Señora, ¿jura usted que el testimonio que está a punto de dar aquí será la verdad, toda la verdad y nada más que la verdad?
Sí, señor.
Yes, sir.
Let's proceed.
Please state your name for the record.
Por favor, denos su nombre para que conste en actas.
Antonia Vane.
Antonia Bang.
Okay. Miss Vane, did you bring suit against Mr. Mohammed individually and as the parent and next friend of Jacqueline Portillo and Jalen Vang for personal injuries occurring on April 18th of 2019 or April 22nd of 2019?
Señora Van, usted levantó una demanda en contra del señor Mohammed individualmente, forma individual y también como padre o representante legal de Jacqueline Portillo y de Antonio, J. Bang, a causa de un accidente ocurrido el abril 18, que diga, perdón, el abril 22 del 2019, ¿es así?
Sí, correcto.
Yes, correct.
Okay, and is that the petition that was filed with docket number DC 1902357 with this court?
Y fue esa la demanda que fue entablada o fue interpuesta y que la pusieron con el número DC 1902357 en esta corte.
Sí, correcto.
Yes, correct.
Okay. Would you state for the record your relationship to Jacqueline Portillo?
¿Nos puede decir, para que conste en actas, cuál es la relación o parentesco de usted con Jacqueline Portillo?
Ella es mi hija.
She is my daughter.
Okay. What is Jacqueline Portillo's birthday?
¿Y cuál es la fecha de nacimiento o el cumpleaños de Jacqueline Portillo?
Es el mayo 16 de 2005.
It's May 16th of 2005.
Right? Four, pero sorry, four.
Lo siento, sorry.
Esto está en four.
I'm sorry, interpreter asking to repeat. Señora, ¿me puede repetir?
Es del el mes de mayo 16 del 2004.
It's May 16th of 2004.
Your Honor, can I interrupt for a second?
Yeah.
I would caution that we don't put any more sensitive information in the record.
Yeah, we're on
beyond-
YouTube right now, Ms. Davi, so if you could be careful about that. I
Okay.
have all of this in the record, so you don't need to go through all of that.
Okay.
And really you should be using initials, but we're kind of past that. So let's try to keep the sensitive data for the minors.
Okay, I apologize, Your Honor.
That's okay.
Okay, may I resume?
You may.
Okay. Ms. Fang, would you please briefly describe the incident that resulted in this litigation?
Señora Bang, ¿nos puede describir de manera breve el incidente que fue la causa de este caso?
Sí, fue una tarde, yo iba manejando en el freeway, me salí al lado derecho del freeway, cuando de repente me impactó en la parte de atrás, del lado izquierdo, el carro, y entonces el carro me pegó a mí, luego se estrelló contra la barda y yo frené y luego me hice a un lado.
Yes, it was an afternoon or evening. I was driving on the freeway, and I was driving straight on the freeway on the right side, and then I was impacted from behind, kind of on the left side, by the car. Then the car hit me, and then hit the wall, and then I went over to the side.
Okay, and can you briefly describe the injuries that Ms. Portillo incurred? I'm sorry.
Y bueno, nos puede también describir de manera breve las lesiones que la señorita Portillo sufrió.
Me lastimé la parte de la cintura y al lado de aquí del cuello.
No, para mí.
Disculpe, ¿yo o Jacqueline?
On my neck. Oh, I'm sorry. It was for me or for Jackie?
For your daughter.
Para su hija.
Lo de ella fue la cintura.
Oh, for her, it was the waist. Interpreter could also mean lower back.
Okay. And did she seek any medical treatment for those injuries?
Y ella buscó tratamiento médico para esas lesiones.
Ese día fuimos al hospital de emergencia y después lo mandaron a terapia. A mi hija Jacqueline, a mi hija Jalen y yo fuimos a terapia.
Yes, that day we went to the hospital ER, And then afterwards, we were sent to therapy, my daughter Jackie, my daughter Jelen, and myself.
Okay, and does your daughter Jackie continue to have any injuries?
¿Y su hija Jackie continúa teniendo lesiones?
No, ya no.
No, not anymore.
Okay, and Ms. Mang, do you understand that we are here today to settle the case against defendants for your minor daughter?
Y bueno, señora Van, ¿entiende usted, está consciente de que aquí estamos para llegar a un arreglo, en este caso, contra el demandado, en el caso para las lesiones de su hija?
Sí, sí, comprendo.
Yes, I do understand.
And is it your understanding of the settlement terms that the defendant and his insurer will pay you individually and will pay you as the parent of your daughter a total amount of $7,100?
Y usted, señora, entiende y está consciente de los términos, de las sumas monetarias que la compañía de seguros va a pagar, en este caso individual y más como padre a usted, como madre, digamos, en un cantidad total de $7,100.
Sí.
Yes.
And do you understand that this is all the money which the defendants and their insurer will pay you? It will pay you for your daughter as a result of this accident.
Y está consciente usted y entiende que esta suma de dinero constituye toda la cantidad de dinero que el demandante y su compañía de seguros van a pagar con relación a las lesiones de su hija en este accidente.
Sí, entiendo.
Yes, I understand.
And do you understand that the money that is paid to you for the benefit of your child will be deposited into the court registry?
Y está usted consciente y entiende que esos fondos, esa cantidad de dinero que se le paga a usted como beneficio para su hija, van a ser depositados en el registro de la corte.
Sí, comprendo.
Okay. And do you understand that this money would be all money except money to cover the expenses of the medical that was incurred?
Y entiende usted y está consciente de que esta es la cantidad de dinero a excepción de los gastos médicos que han incurrido.
Sí, comprendo.
Yes, I understand.
Are you voluntarily entering into the settlement agreement?
Y usted está entrando en este acuerdo de manera voluntaria.
Sí, estoy de acuerdo.
Yes, I'm in agreement.
Okay, and do you believe it is in the best interest of your daughter to settle the case in accordance with the terms we've just outlined?
Y usted cree que este es el mejor interés de su hija, su mejor interés, el alcanzar este arreglo, como se le ha explicado en esta corte, en esta demanda.
Sí, sí, estoy de acuerdo.
Yes, I'm in agreement.
Do you also understand that by not settling this case, you would be entitled to a jury trial of the defendant's case?
Y también entiende usted que si usted no entrara en este acuerdo, tendría el derecho de un juicio por jurado en esta corte.
Sí.
Yes.
Okay. And do you understand that a jury could award you more money, less money, or no money at all as a result of a trial regarding the incidents for your daughter's injuries?
Y entiende usted que si hubiera un juicio con jurado, el jurado podría otorgarle a usted ya sea más dinero o podría ser menos dinero o incluso nada de dinero en un juicio contra el demandante y su seguro.
Sí, estoy de acuerdo.
Yes, I'm in agreement.
Okay, and do you also understand that by settling this case, you're giving up the right to a jury trial?
Y entiende usted y está consciente también de que al entrar en este acuerdo, usted está renunciando al derecho de tener un juicio con jurado.
Sí, estoy de acuerdo.
Yes, I'm in agreement.
Okay. And do you understand that by accepting the settlement today, any existing injuries to your daughter and any injuries which may arise that may not be known at this time would not be recoverable in the future from either the defendant or the defendant's insurance?
Y entiende usted también y que al aceptar usted este acuerdo y este arreglo, cualquier lesión que aún exista, que tenga su hija, o alguna lesión que esté en existencia, pero de la cual no se sabe aún, no se podrá recuperar ya nada por parte en el futuro por parte del demandado o de su compañía de seguro.
Sí, estoy de acuerdo.
Yes, I'm in agreement.
Okay. Based on all that we've set forward today and in the record before the court, do you still want the judge to approve the settlement?
Y basándose en todo lo que hemos hablado y hemos hecho constar en actas aquí, ¿aún está usted pidiéndole al juez que apruebe este acuerdo?
Sí, por favor.
Yes, please.
Great. Now, Ms. Vang, we're going to talk about your younger daughter, who I will refer to as JV. Do you understand that?
Y bueno, señora ahora vamos a comenzar a hablar de su otra hija, a quien nada más nos vamos a referir con las iniciales JD. ¿Entiende usted eso?
Sí.
Yes.
Okay, would you state for the record your relationship to JV?
Nos puede dar, para que conste en actas, cuál es el parentesco de usted con JD.
Ella es mi hija, es JB.
She is my daughter. She's a JV.
Would you briefly describe the incident that resulted in this, never mind. Would you briefly describe the injuries that JV sustained as a result of the incident that's the basis of this litigation?
Y bueno, ¿nos podría describir usted con brevedad las lesiones sufridas por JV en este accidente que son las bases de esta demanda?
Sí, fue la cintura la que se lastimó, fue a terapia también igual que nosotras y estuvo en el hospital y fue a terapia, estuvo en el hospital después que tuvimos el accidente y después fue a terapia.
Yes, it was the waist. Interpreter could also mean lower back. She went to therapy just like us, and then she was also in the hospital first, and then on the time of the accident, and then later therapy.
Okay, and does she continue to have any medical problems today?
Y ella sigue teniendo problemas médicos actualmente hoy.
No.
Okay.
No.
And do you understand that we are here to settle JV's case against defendants today?
Y entiende usted y está consciente que aquí estamos para llegar a un arreglo en contra de los demandados en el caso de JB.
Sí, estoy de acuerdo.
Yes, I'm in agreement.
Okay, and is it your understanding of the settlement terms that the defendant and his insurance will pay you $5,400 to settle the claims in this lawsuit?
Y está usted consciente y entiende que el demandado y su compañía de seguros van a pagar la cantidad de $5,400 para alcanzar un arreglo en las lesiones de su hija.
Sí, estoy de acuerdo.
Yes, I agree.
And you understand that this is for the benefit of JV?
Y entiende usted que esto es para el beneficio de JB.
Sí, estoy de acuerdo.
Yes, I agree.
Okay, and you understand that the money is in the amount of $5,400 is all the money which defendants and their insurance will pay you and JV as a result of this incident for her injuries.
Y entiende usted, está consciente de que esta cantidad de $5,400 será todos los fondos que el demandado, perdón, y su compañía de seguros van a pagar a usted y a JB con relación a las lesiones de ella.
Sí, estoy de acuerdo.
Yes, I agree.
Okay, and do you understand that you will be placing any money which is not used for the medical expense, not used to pay the medical expenses or other expenses related to the suit for your daughter into the court registry?
Y está usted consciente y entiende que usted, todos los fondos que no sean usados para pagar los gastos médicos, el tratamiento médico de su hija JB, serán depositados en el registro de la corte.
Sí,
Yes.
Okay, and are you voluntarily entering into the settlement agreement today?
Y entonces, ¿está usted entrando en este acuerdo por su propia voluntad?
sí,
Yes.
Do you believe it is in the best interest of JV to settle this case in accordance with the terms we've just outlined?
¿Y está usted de acuerdo o piensa usted que el alcanzar un arreglo en los términos que hemos hablado hoy va a ser en el mejor interés de su hija JB?
sí, señor.
Yes.
Okay. And do you understand that by not settling this case, you would be entitled to a jury trial of the defendants for the injuries sustained by JV?
¿Y entiende usted que el no alcanzar un arreglo en este caso querría decir que sí podría haber un juicio por jurado contra el demandado por las lesiones sufridas por JB?
Perdón, ¿me puede repetir la pregunta?
I'm sorry, could you repeat the question?
Yes. Do you understand that by settling the case, you would not be entitled to a jury trial against the defendant for the injuries sustained by JV?
Y entiende usted y está consciente que el alcanzar en este acuerdo significa que no va a poder tener un juicio por jurado en contra del demandado por las lesiones sufridas por JB.
Sí, estoy de acuerdo.
Yes, I agree.
Okay. And do you understand that a jury could award you more money, less money, or no money at all as a result of a trial regarding the accident and JV's injuries?
Y entiende usted que si hubiese un jurado, ese jurado podría otorgarle a usted ya sea más dinero o menos dinero o incluso nada de dinero como resultado de un juicio con relación a las lesiones sufridas por JB en el accidente.
Sí, entiendo.
Yes, I understand.
Do you understand that by settling this case, you're giving up your right to a jury trial?
¿Entiende usted que alcanzando este arreglo significa que usted renuncia al derecho de tener un juicio con jurado?
Sí, entiendo.
Yes, I understand.
Okay, and do you understand that by accepting the settlement today, any existing injuries to JV and any injuries which may arise in the future would not be recoverable against the defendant or his insurance?
¿Y entiende usted que al aceptar esta oferta de arreglo, ya cualquier lesión que exista ahora o que se desarrolle que se vea en el futuro, no podrá ser recuperada del demandante o del demandado, perdón, o de su compañía de seguro?
Sí, entiendo.
Yes, I understand.
Based on all that we've set forth in the record today before the court, do you still want the judge to approve the settlement?
Y basándose en todas esos que hemos dicho, que consta en actas aquí, ¿todavía está usted pidiéndole al juez que apruebe este arreglo?
Sí, por favor.
Yes, please.
Great. I pass the witness, Your Honor.
All right, Ms. Meeks or Mr. Young?
I anticipate my questions will be duplicative of Tamara's and Ms. Meeks and Ms. Dovey's.
Okay,
So
so you don't have
I'll
any
defer to
questions?
Ms. Meeks.
Ms. Meeks?
Yes, I just have a few questions, Ms. Fang. I believe earlier in the testimony, the accident at one point was referred to as occurring on April 22, 2019. It actually occurred on April 22, 2018, correct?
Y mire, antes aquí en este testimonio parece que se mencionó que el accidente había ocurrido en la fecha de abril 22 del 2019, pero de hecho ocurrió en la fecha de abril 22 del 2018, ¿no es así?
No me acuerdo. No sé, no me acuerdo si era el 2018. Es como hace mucho tiempo que pasó, no me acuerdo.
I don't remember. I don't remember if it was 2018. It's been a long time.
Okay. Both of your daughters completed their treatment with any doctor within 1 month of the accident. Do you recall that?
Ambas hijas de usted concluyeron su tratamiento dentro del plazo de 1 mes después del accidente. ¿Está usted de acuerdo en decir eso?
Sí,
Yes.
And both of your daughters have made a complete recovery, correct?
Y ambas hijas de usted han alcanzado una recuperación completa. ¿Está de acuerdo?
sí.
Yes.
Now, you and I and both of your daughters have kind of spoken on the telephone kind of as a group with your daughters acting as interpreters for us. Is that correct?
Y bueno, usted y yo y sus hijas, ambas, hemos hablado ya por teléfono en conversación de grupo con sus hijas haciendo el papel de intérpretes. ¿Es cierto eso?
Sí.
Yes.
Additionally, in the same fashion, you and your daughters and I have met in a Zoom conference such as this to discuss the case and your daughter's injuries. Do you recall that as well?
Y bueno, también usted y yo y sus hijas ambas también nos tuvimos una conferencia aquí en Zoom, como estamos haciendo hoy, para hablar de esto. ¿Recuerda usted eso?
Sí.
Yes.
And both in the telephone conversation and in our Zoom conference, I explained to you that I was appointed by the court to act as a special representative to investigate the settlement because both of your daughters are under the age of 18.
Y creo que tanto en esa llamada telefónica como en la conferencia de Zoom, yo le expliqué a usted mi papel, cómo yo fui, el tribunal, la corte, ¿verdad? Me dio el papel de investigar este accidente y el arreglo como representante especial debido a que sus hijas son menores de 18 años.
Sí, correcto.
Yes, correct.
Do you understand my role in the case?
Entonces, ¿usted entiende cuál es mi papel en este caso?
Sí.
Yes.
Do you believe I've acted in the best interest of both of your daughters?
¿Cree usted que yo he actuado en el mejor interés de sus hijas ambas?
Sí.
Yes.
Pass the witness.
Paso al testigo.
Okay. Do we have, Mr. Jenkins, did you have any additional questions?
No, Your Honor, everything was covered.
Okay. Ms. Meeks, do you have a recommendation?
Yes, I do, Your Honor. Previously, I filed a guardian ad litem report on each of the minors, setting forth the pertinent information regarding their injuries and their treatment and payment of the medical and the money that they will be receiving. The money that each daughter will be receiving is not enough to do anything other than deposit it with the registry of the court. And so I am recommending that. The accident occurred on April 22, 2018. Both daughters had completed their treatment within 30 days. Both injuries were minor. Actually, the younger daughter, JV, reported that she was not injured. JP recovered from her injuries very quickly. She primarily suffered from some headaches. It appears that their medical treatment was appropriate. They have repeatedly confirmed to me that they've had complete recovery. Their mother has confirmed that as well. It looks like plaintiff's counsel did a good job of getting the medical bills reduced. They are not taking a fee in excess of 1/3, and their expenses are reasonable. So that the recovery from the settlements, I think, on behalf of each minor, is a good recovery, and I am recommending the settlement as presented to the court.
Okay. Ma'am, the mother, does she have any questions for me?
Señora, la madre, ¿tiene usted alguna pregunta para mí, el juez?
No, señor.
No, sir.
And you want me to approve this settlement?
¿Quiere que yo apruebe este arreglo?
Sí, señor.
Yes, sir.
All right, the court will approve the settlement as requested. Has there been a discussion about Ms. Meek's fees?
Yes, Your Honor.
And is there an agreement as to the amount of Ms. Meek's fees?
Yes, Your Honor.
What is that?
Your Honor, there's been a previous agreement for $3,360 based on my estimate, which I actually exceeded, of 11.2 hours at $300 an hour. That is incorporated both in the order approving guardian ad litem fee, which was previously e-filed, and it's also incorporated into the judgment as well.
Okay, and you did two different ones. So, okay, great. Thank you so much. Let me see if I see the judgment. I have not seen the other document, so let me see if I can find that. But Ms. Meeks, thank you so much for your service to the court.
You're welcome, Your Honor.
We appreciate you getting this done, and glad we were able to get this one taken care of. Do you know what day you submitted the order concerning your attorney's fees?
The order regarding the guardian
it.
ad litem fee was, yes.
I see it. Okay, let me see if I can print it. Right. All right, well, we'll take care of this. We'll get both those things signed. Did you find it? There you go. You can take both of these. There we go. All right, thank you so much.
Thank you.
Ms. Meeks, and you guys be safe, okay?
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, bye, everyone.
Thank you.
Bye.
Thank you, Tamar.
You
Thank you,
are
Tamar.
welcome.
Bye, thank you.
All right, Mr. Fall, did you guys work everything out? Mr. Reed, Mr. Fall?
I'm sorry, Derek.
I'm sorry, go ahead, Glenn.
Yeah, Your Honor, this is Glenn Fall. I believe peace is broken out. We have a good tentative agreement on topics. I'm going to formalize it. Mr. Reed will approve it, and I don't think we're going to have any issues.
All right, if you could go ahead and get me an order on that. When you submit the order, can you make sure it says on June 18, 2021, the court made the following orders opposed to on this date? If possible, if you guys could all three sign off on it and then e-file it with the court as well as emailing my court coordinator.
Okay. Court coordinator. I'm making notes as you speak.
And then if you could get that to us by, if possible, by next Monday, that'd be great.
Mr. Reed's going on vacation next week. Is it possible we can do it like when he gets back?
You couldn't do that today. You couldn't get the order done today.
I'll do my best. Are you going to be around, Mr. Reed, this afternoon?
I actually have to go walk through something in Fort Worth. But Glenn, just send it to my phone and I'll look at it on my phone and give you permission if everything looks good for you to sign on my behalf.
Okay, that works. I will do that.
It's just easier for me if you can get it to me by Monday. I'm not trying to give you a hard time. It's just, it'll be harder for me to sign it later. So if you, I'm also going on vacation next week too, Mr. Reed. So I understand that. You guys have a great time and you guys be safe. Okay.
Thank you very much.
All right. Thank you.
All right, Glenn, talk to you soon.
Okay. Let's go to the next hearing. So is there anyone here on Discover Bank versus Liberato?
Yes, Your Honor.
All right. Ms. Liberato, are you here? Ms. Liberato, I think is Ms. Liberato, you're here. Can you unmute, please? And Mr. Cherian, are you here for that case as well?
Yes, Your Honor. We're here on behalf of Discover Bank.
Okay. Ms. Liberato, can you unmute, please?
Oh, there you go. Can you hear?
Yeah.
Good morning, Ms.
Good morning. Have you guys tried to work anything out on this yet?
Well, they have it here because I have citation for discovery. Yes, I have.
Yes, she has, Your Honor. I'm her son.
Yeah, because I need some translate, please.
Can we get a translator, or would you like a translator?
My son can translate.
We don't have a translator. Ms. Lozano,
Okay.
can you maybe try to translate?
Okay. Yes.
She's not
Okay,
an
so
official translator.
She did try to I'm her son. She did try to contact them, and they wanted a lump sum of money, which she doesn't work right now. So we tried to make a settlement with them too, and we just don't have the money. She doesn't work, and I was paying for her monthly. So I don't have a job now, but I think I just got hired at Four Seasons. So that's where we're at with that.
Okay. All right, let's do this. I'm going to put you guys into a breakout room, see if you can't work something out. Mr. Cherian, have you talked to her at all about a settlement?
I have not myself, no.
Okay, I'll give you guys 5 minutes to try to work out a settlement, and then we'll bring you back in, see if you guys can't work something out.
Thank
Okay.
you.
Thank you.
Okay, give me 1 second. I'm going to go mute for a second.